I've been asked to describe today what you should expect if you have a personal injury case with my firm. Well, the first thing that's going to happen is you're going to have an extensive intake where we take all of your background information, work history, all of the doctors you've ever treated with, and we're going to put that all into our system and we're going to set it up so that you have easy access to us. At the same time, we're going to make sure that you're being treated by the best doctors in the area. Once you have reached what I like to call the maximum level of recovery, we're going to collect all of your records together and we're going to put a demand package together to the insurance company to resolve your case. Most of the time, demand packages don't work because insurance companies don't like to pay me what I ask for. So I'm forced to sue them. We're going to file a lawsuit in the county in which the incident occurred and then begin litigation. First, there's going to be what's called paper discovery, interrogatories and requests for documents. We'll send those to the other side. They'll send them to us, and we'll go over them with you to make sure that you answer all the questions in the interrogatories and that you produce all the documents that they're requesting. After the paper discovery is over, we'll begin doing what's called depositions. Depositions are a question and answer format where a stenographer is present, sitting across from the other side, and their lawyer will ask you questions and you'll answer them. And before that ever happens, I'm going to prepare you for that deposition. I'll be there with you. Then it'll also give me an opportunity to ask the other side questions and get to the bottom of how the accident happened and proving their liability. At the conclusion of discovery, there's normally something called a settlement conference. That's when both sides come together and see if they can resolve the case now that all of the discovery has concluded. My philosophy generally is I prepare cases for trial. I want the other side to know that if they don't settle with me, that I'm prepared to go forward. We'll have all of our expert reports prepared at this point, all of our doctors ready to take the stand to explain exactly the nature and extent of your harm and the long-term consequences. I know most of my clients don't like to go to trial, but I can tell you it's my favorite part of my job. Being in the courtroom is just so much fun for me as a lawyer personally, so I cherish the opportunities I get to try cases. You're going to testify at the trial in front of a jury, and I'm going to prepare you for that testimony. I'm going to cross-examine all their witnesses. We'll give opening and closing statements, and at the end, the jury will return a verdict, and hopefully it will be in our favor and for a very large number. What happens after that, the other side has the option of either paying the judgment that has been ordered against them, or they can appeal the trial. If they appeal, it could drag it out for probably another 6 to 18 months. Most of the time that doesn't happen. Normally we're able to resolve it. We'll have a check within 30 days. If you wanted an average ballpark of what litigation will take, start to finish, it would be 12 to 18 months.